The next case on the call of the docket is agenda number 20, case number 126835, in re the marriage of Betsy Dynako and Stephen Dynako. Mr. John August Stas.
Good morning, Your Honors. Good morning, Counsel on Zoom. My name is John August Stas, and I'm appearing on behalf of Respondent Appellant in the matter of the former marriage of Stephen Dynako and Betsy Dynako. The issue before us this morning is whether Section 502F of the Illinois Marriage and Dissolution of Marriage Act bars the court from modifying maintenance in the circumstances of this case. Respondent Stephen Dynako entered into a marital settlement agreement calling upon him to pay $60,000 per year in maintenance for 4 years, and then maintenance obligation would decline by $10,000 per year in subsequent years for a total of 8 years. He filed a motion to modify maintenance, seeking to show that despite his best efforts, he was unemployed, had no assets, and was unable to find employment anywhere near a level that would allow him to pay $5,000 a month. In short, he seeks to show that the maintenance obligation is, as a practical matter, impossible of performance. Now, we didn't reach that question in the trial court. The trial court ruled that whether or not his performance is impossible, whether or not he can make the payments, the court has no jurisdiction to modify the maintenance obligation. The court is barred from modifying the maintenance obligation by Section 502F of the IMDMA. Now, that bar comes from a sentence in the marital settlement agreement which provides, maintenance payments shall be non-modifiable pursuant to Section 502F of the Illinois Marriage and Dissolution of Marriage Act. It is our position that this sentence of the MSA does not comply with the requirements of the statute, and by the express terms of the statute, maintenance is therefore modifiable if Stephen can show a change of circumstances. Now, I ask the court to consider carefully the statute 502F. First, a maintenance obligation is entirely a creature of the statute. It is not a matter of private common law contract. Indeed, this court has long held that private parties cannot enter into a private common law agreement for maintenance or alimony outside the statute. Hewitt v. Hewitt held that in 1979, and this court reaffirmed the continuing vitality of Hewitt 5 years ago in Blumenthal v. Brewer. So the maintenance obligation lives and dies by the terms of the statute, 502F. Now, the general rule under the statute is that maintenance is modifiable. In Bloom v. Koster, 12 years ago, this court held that the trial court is without authority to make a maintenance obligation non-modifiable except by the express agreement of the parties as set forth in 502F. And the court's language there is important. And I quote, "From a practical view, the obvious need for modifiability is summed up in a phrase: life changes. The only certainty in life is the probability of life's ever-changing nature in the lives of divorced spouses. To conclude otherwise simply defies common sense and life experiences." Therefore, this court held that the trial court erred in ordering a maintenance award non-modifiable and non-reviewable absent express agreements by the parties pursuant to 502F.
Counsel, isn't that what happened here? Didn't the parties expressly make it non-modifiable by referring to 502F?
Well, in the interim, since Bloom v. Kostner, the statute changed. And that's what's important to this case, I believe, and that's what this case turns on. You are correct that the parties did enter into an agreement that said the sentence that I just quoted you. But in the 2016 amendments to the statute, the legislature added 4 sentences to the previously existing 502F. The earlier language remained, but 4 new sentences were added addressing non-modifiability in a marital settlement agreement with respect to child support, maintenance, and the division of property. One sentence provides that child support is always modifiable. Another sentence provided that the property division in a marital settlement agreement is never modifiable. So one sentence for child support, one sentence for property allocation. When it came to maintenance, the legislature added 2 sentences. And the language in those 2 sentences, I think, is crucial here. It says, the parties may provide that maintenance is non-modifiable in amount, duration, or both. If the parties do not provide that maintenance is non-modifiable in amount, duration, or both, then those terms are modifiable upon a substantial change in circumstances. So, the legislature set a requirement before the non-modifiability clause can be effective. There has to be a provision that maintenance is non-modifiable in amount, duration, or both. If that designation, amount, duration, or both, isn't made, then those terms are modifiable upon a substantial change in circumstances. Now, if the legislature had wanted to say, as some would argue, I believe as counsel is arguing, that in the absence of a designation of amount, duration, or both, then the designation is going to be inferred that the parties intended to say that the non-modifiability applies to both amount and duration. But if that's what the legislature had intended, that's not what it said. That's not what the language said. That language could have been added, but that's not what it says. Instead, it says, if the parties do not provide that maintenance is non-modifiable in amount, duration, or both, then those terms are modifiable upon a substantial change of circumstances.
Counsel, in the agreement, in the section that we're looking at here, doesn't it say that the respondent agrees to pay petitioner for her maintenance the sum of $5,000 per month for 4 years, and then it goes on and sets out a schedule
Correct.
of the amount and the duration of this obligation? And then the next sentence says, said maintenance payments shall be non-modifiable pursuant to the statute. Is that part of the agreement ambiguous?
I think it is, and here's why. Because it refers back to section 502F explicitly. And
The sentence itself, here is a schedule of duration and amount. Next sentence, said maintenance payments shall be non-modifiable. Why doesn't the expression said maintenance payments refer back to the schedule of duration and amount?
Well, it does refer to the schedule of duration and amount, but it doesn't say said maintenance payments are non-modifiable in duration and amount. It doesn't
So there has to be
specify.
those magic words.
I don't think those are magic words. I think those are words required by the statute, that it has to say both duration and amount. I think there are lots of places in the law where there are terms of art or statutory requirements in a statute that say there has to be, that a specific term has to be made. For example, as I note in my brief, in a mechanics lien, in order for a mechanics lien to be effective, it has to be filed within 4 months of the date that work is completed to be effective as to subsequent purchasers. If it's 4 months and 1 day, the lien fails. If the landowner asks the contractor has to provide a sworn contractor statement. If he doesn't provide it, the lien fails. In order for, and lawyers are well skilled in using terms of art that are prescribed by statute or by rule in meeting the requirements. For example, in order for us to get here, there had to be 304A language added to the judgment, which it was added. But because this refers back to 502F, I think that underscores that it's referring back to the statute which says that amount, duration, or both have to be designated. And I don't think that was done here, and I don't think...
What's the meaning of this phrase in the divorce judgment then that says it's non-modifiable pursuant to this section? Does it have any meaning at all?
Well, I think that's where I think that's where the inartfulness of the drafting of the marital settlement agreement fails. I mean...
No, wait a minute. The judgment says that the above sections are non-modifiable, right?
It says that the payments are non-modifiable, yes.
So what can that possibly mean then in your judgment? What's non-modifiable in your judgment? I mean, it says right there, non-modifiable. It's a statement.
Well,
So
first...
does that have any meaning in your analysis?
It could refer to the amount or the duration or to both, but it's not designated which it is.
I mean, what's non-modifiable then in your view? Nothing?
I think that under the statute, it doesn't meet the requirements of the statute because it doesn't designate which of those it is.
So it has no meaning at all?
I think it fails to become effective under the terms of the statute.
So similarly, if the term had said it's non-modifiable as to amount pursuant to the section,
Yes.
would it be your position that means that's a nullity? In other words, it would be modifiable both as to the amount and duration because it doesn't say both.
No, if it had said it's non-modifiable as to amount, then it would have complied with the statute because it would have designated that it's non-modifiable as to amount.
But it
And
would be modifiable as to duration?
It would be modifiable as to duration if that's if it had said in the marital settlement agreement that it's modifiable, that it's non-modifiable as to amount, then it would have designated that the non-modifiability applied to the amount and not to the duration, so it would have been modifiable as to the duration. And that's exactly the problem that we have in this, the problem that I'm faced with in this case.
So you believe that term in the marital settlement agreement is really a nullity, is that right?
I think it's ineffective because it doesn't comply with the terms of the statute, that's right. I think it's because it doesn't comply with the terms of the statute, which requires the designation of amount, duration.
Well, this also says pursuant to 502F, correct?
Exactly.
Okay, and 502F says what it says, and it's bringing in 502F to the judgment, right? Non-modifiable as to 502F.
And 502F requires that that designation be made as to whether it's non-modifiable as to amount, duration, or both. So, and if it fails to make that designation, amount, duration, or both, then by the express terms of the statute, the maintenance obligation is modifiable upon a showing of a change of circumstances. And I think...
Well, in the statute, it indicates you can make it non-modifiable,
Correct.
and these things, and they talk about, in this judgment, they have 502F.
Yes. But again, 502F requires that the designation be made as either non-modifiable as to amount, or as to duration, or as to both amount and duration.
Is there any statement in the statute that says the above stated words have to be explicit in the judgment?
The statute doesn't, the statute just has the words that I just quoted to you. That's what the statute says. And I'm not saying that there have to be magic words. I'm saying there has to be something there that says that the designation is made as to amount and duration. Now,
Well, can you give me an example? If you don't use those words as magic words, what's an example under your theory that would include the concept you say is excluded? What other words would you have?
sure, these payments, if the marital settlement agreement had said these payments are non-modifiable in amount and duration in accordance with 502F, that would have satisfied the statute. If it had said these payments are non-modifiable as to amount pursuant to 502F, that would have satisfied the statute.
Both amount and duration in that example?
Or both amount and duration, that would have satisfied the statute.
Where-
Or these payments are non-modifiable in duration in accordance with 502F. In other words, something from those terms as specified in the statute that the statute specifies.
So in your examples, it always contains the word amount and would always contain the word duration, or maybe one.
Well, I suppose there other words could have been used that mean the same thing, like in amount and time, or in dollars and time, something, I mean, other synonyms for those terms. But I think something dealing with those concepts has to be there under the statute. And I think otherwise, the statute becomes a nullity. And here's why. The terms amount, duration, or both were added into the statute prior to the 2016 amendments. The statute provided that the parties could agree to modify any terms of the judgment, including maintenance. This new language was added specifying amount, duration, or both. Now, any judgment has to say, any maintenance judgment to be effective has to have an amount and has to have a duration. Otherwise, it's not a maintenance judgment. So the fact that an amount and a duration were set forth in the judgment doesn't mean there's compliance with the statute unless the designation is made, amount, duration, or both. So I don't think there's compliance with the statute here. And the inference has to just come from the plain, that there is compliance, that a designation is made of amount, duration, or both, would have to come from the plain language of the statute. The plain language of the marital settlement agreement, because no extrinsic evidence was introduced on that subject. It just came from the language of the statute. If extrinsic evidence had been permitted, we would have introduced letters and emails to show that Mr. Dynako, who was not represented by counsel, intended this to accommodate his uncertain employment status and income so that the amount and duration would have to vary based on his changing circumstances.
Can I go back to my earlier question? Then in your view, that statement in the marital settlement agreement, non-modifiable, has no meaning at all. It's meaningless.
It's not that it's meaningless, it's that it's not effective because it doesn't comply with the statute.
Well,
So I think it's ineffective in that it doesn't, in that the marital settlement agreement by operation of the maintenance obligation should be modifiable because that's what the statute says. That if you don't designate amount, duration, or both in your attempt to make it non-modifiable, then it's modifiable.
So in your view, it really reads modifiable because it didn't contain that other language.
I think the maintenance obligation would be modifiable, yes. I wouldn't attempt to rewrite the language of the marital settlement agreement to make it comply or not comply. I just think that on its terms, the marital settlement agreement doesn't meet the threshold that's required by the statute. And the consequence of this is enormous. And that's why I think it's important that there be strict compliance with the requirements of the statute. What happens is that if a marital settlement agreement, if the maintenance obligation is not modifiable, what happens then is that, I see my time is up.
Thank you, Counsel.
The situation for the respondent, for the obligor, is a parade of impossibilities. Thank you.
Thank you, Mr. Stas. Mr. Dunn, welcome to the Supreme Court.
Good morning, Your Honors. May it please the court, Colin Dunn on behalf of the appellee. I apologize for not being there in person with you all this morning. The parties agree that 502F allows them to make the maintenance obligations in the MSA non-modifiable. So the issue, I think, before the court is, did the parties do that here? And in our view, the first step in the analysis is, are there any special requirements in 502F? And by the way, the marital settlement agreement was signed January 29th of 2016 after 502F was amended. So it was signed under the current version, or at the time, I guess, the current version of 502F. There's simply no evidence that the General Assembly intended that the parties use any specific language in order to comply with 502F. And we know that the General Assembly knows how to do that when it wants to. We've cited examples in our brief that when they want the parties to use specific language, or even language that's substantially similar to a certain phrase, they signal that, whether it be in a prefatory language within the statute or by punctuation, such as a quotation mark or after a colon, and including in the act itself. We've cited 508, which has language that's required for the agreement between the lawyer and his client that must be in the agreement, and that's set off by a colon and in quotation marks. There's none of that language in 502F. So we think the next step then in the analysis is, well, did the MSA, in the MSA, did the parties agree clearly to make the maintenance non-modifiable? And we think they did that here. And this court in Bloom has explained that in making that determination, you apply contract interpretation principles. And so that's, you look at the plain language of the MSA to find the party's intent. And as Justice Tice pointed out, if you look at section 2.1, there's a detailed maintenance schedule. There's amounts that are owed, there are dates those amounts are owed by, and there's a year limitation, 8 years of maintenance payments. So there's amounts and there's durations set forth in the MSA. And immediately following that detailed schedule is the phrase, said maintenance payments shall be non-modifiable, and then cites 502F. I think it's important to note that even today, and in every step of this litigation, Stephen has never provided an alternative reading of that language. He's never identified a reading that would call into question or create an ambiguity as to the party's intent to make the maintenance obligations non-modifiable. And this court has explained that just because the parties might differ in meaning or reading of a provision doesn't make it ambiguous. But here, there's no other side of the coin. There's no other reading that he's offered the court that would create an ambiguity as to whether or not the parties intended that the maintenance obligations set forth in detail in the MSA are non-modifiable. There's simply, in our view, no other reading, no other reasonable reading of the MSA language.
Can you hear me? Excuse me. Can I ask a question?
Yes.
There was a prove-up in this case, correct?
I wasn't trial counsel, Judge, so I don't really know if that happened or not. I'm sorry.
So there's nothing in this record that I can tell that shows what happened at the prove-up, is that right?
I don't know one or the other, Your Honor. I don't know if that happened or not. I do know, though, at the time the MSA was signed that Stephen had lost his job. He was no longer working. I was told that, but I was not involved in the trial proceedings, unfortunately.
I mean, somebody testified in court, right? To get this judgment and settlement agreement approved?
I don't know that, Judge. I'm sorry. We feel, as many of you pointed out this morning, that the citation to Section 502F in the MSA seals the interpretation that we're offering. There's no other reason for the parties to have cited 502F other than to confirm that those maintenance payments that are laid out in the MSA are not modifiable.
Counsel, can
So-
I ask, Mr. Dunn, may I ask another question? Opposing counsel said that the appellate court said, the trial court said it did not have the authority to modify the agreement. And I think opposing counsel just said that the court said it didn't have jurisdiction. Now, those are big, important words. Here, from what we can understand, the husband was self-represented, and this agreement was drawn up by the wife's lawyer. And at some point, at least, we're told that the husband said, I wouldn't have signed it if I understood that it was non-modifiable. So my question is really about the big ideas like jurisdiction and authority and void versus voidable. Is this agreement subject to contract defenses? Could there be another argument made here that the court could entertain about the intent of the parties when they entered into this agreement?
I don't think that's a jurisdictional issue, Judge. I don't think that that's the right terminology in this case. I think the statute bars any modification to the MSA if the parties set forth in the MSA and the judgment order that the maintenance obligations are non-modifiable. At that point, if that's the case, if that's the way the MSA is set forth, then that's the end of the story. The post hoc affidavits or affidavit of Stephen would not be admissible anyway. It's not as if a party to a contract can file after the fact an affidavit saying, I didn't know what it said, and that somehow voids the contract. That's parole evidence that wouldn't be allowed anyway. So the affidavit that he filed in connection with the motion to modify doesn't change the analysis. If you're applying contract interpretation principles, as this court says it should, in interpreting an MSA, the first step is, what does the MSA say? And is there any ambiguity? Only if there's any ambiguity do you resort to extrinsic evidence potentially. But we don't have any ambiguity here. As I pointed out before, there's been no alternative reading of that sentence that we've talked about, the said maintenance obligation sentence, that would create an ambiguity. So there's no reason to consider other contract defenses because you can't get past the language of the MSA. I do want to talk briefly about the strict compliance issue. As we've said before, there's no evidence that the General Assembly intended a verbatim language requirement in 502F. If the statute truly is a degradation of the common law, which we'll accept as true for purposes of this argument, what Stephen's asking this court to do would actually contravene that principle. He's asking the court, even though he says, I'm not saying it's a magic word requirement, that they have to use duration and amount. That's repackaging a magic word argument. He's saying that those words have to have been in the MSA. And again, there's no evidence that the legislature asked that or intended that. So it would in fact be not strictly construing the statute to add those requirements, to add a requirement that language be required in the MSA, or to add punctuation, for instance, as the legislature has done in the past. The strict compliance issue, again, we think that they've kind of melded two concepts together, the degradation of the common law, strictly construing concept, and the strict compliance concept. Strict compliance refers to whether or not a statute's mandatory versus permissive. And in this case, the parties aren't required to even address maintenance in their MSA. So it's a permissive statute in the first instance. But even if it were a mandatory provision, substantial compliance is okay. That's enough to satisfy even a mandatory provision. And here, as many of you pointed out this morning, what they said in the MSA complies with 502F. There's just no other way to reasonably read that sentence especially in its context, as saying anything other than the parties intended that the maintenance obligations be non-modifiable. So with that, unless there's any other questions from the court, we would ask that the court affirm the judgment of the trial court and the appellate court and find that the maintenance obligations in the MSA are non-modifiable. Thank you.
Thank you, Mr. Dunn. Mr. Stoss?
Thank you, Your Honor. First, to answer the question about the prove-up. At the prove-up, Mr. Dynako was not present and there was no court reporter. Mr. Dynako's appearance and the stipulation for an uncontested prove-up were all drafted and filed by Ms. Dynako's attorney. I think with respect to counsel's argument that there's no indication that the legislature, as I take it, meant what it said when it drafted the statute, saying that there has to be a designation of non-modifiability as to amount, duration, or both, that's there for a reason. And the reason is that the maintenance obligation, the enforcement provisions for a maintenance obligation are among the most extreme in the law with respect to civil penalties, with respect to civil enforcement. For example, and I think that that language is intended as sort of a guardrail to say that there has to be a designation of one amount or duration, or both amount and duration, and that needs to be specifically and clearly and unambiguously expressed. Unlike other debts, a maintenance obligation cannot be discharged in bankruptcy. Now, and Mr. Dynako has filed for bankruptcy, but this obligation continues to go on. The court can take away his passport and driver's license. It can attach all of his assets, including his retirement accounts, under in re Marriage of Thomas, and that was done in this case also. The retirement accounts that he was awarded in the divorce judgment were taken and all given to Betsy, the appellee. That's already been done. The court compels him to keep a job diary now, and to come in and report to the court on his efforts to find a job. Now, in this case, that's especially problematic where the maintenance obligation has become impossible of performance because he can't find a job paying $5,000 a month, or now with arrears and interest, $6,000 or $7,000 a month. So he's out looking for a job by court order, shoveling snow, mowing lawns, and he continues to fall farther and farther behind.
Counsel, didn't he voluntarily leave his position? And I'm not sure if this is relevant or not, but didn't he voluntarily leave his position?
Well, he says he was under pressure from his job and he was likely to lose his job, but he did absolutely resign, and that was before the judgment was entered. And after that, he was seeking avidly to get back into the banking business, but found that his degree was, and his experience was stale. Apparently the banking business changes all the time, and after a couple of years of being out of it, he wasn't up to date on the new regulations, and he's been unable. He submitted a job diary showing hundreds and hundreds of job applications trying to get back into that business, and he wasn't able to do it. Point is that, and then he can be put in jail if he's not making enough money. And furthermore, the court has to spend its time supervising him now for the rest of his life, micromanaging his life for the next 20, 30 years. He's paying half of his, whatever he makes, to his wife and to his ex-wife. The judge has ordered him to go out and find whatever employment he can. So again, shoveling snow, cleaning sidewalks, raking leaves. And he gives half of that to his ex, but then he has to, at some point, the court says, well, did you really need to buy those new shoes? Maybe they could have lasted another year. It's a real burden on the court to have to micromanage him. Furthermore, the court cannot spread out his payments over a longer period of time. There's no remedy in the court for this situation. The court can't say, if the maintenance is non-modifiable as to amount, duration, or both, then he can't, the court held that it can't spread out his payments over time and say, okay, pay $2,000 a month over a much longer period of time. What happens is he's still in contempt for not having $5,000 a month or $6,000 a month to pay, and the debt keeps accruing 9% interest. The arrears get higher and higher and higher, and every month he's falling farther and farther behind. All of this is what happens as a result of a civil judgment that the court couldn't do without an agreement in compliance with 502F. Therefore, I submit that the language of 502F requiring a designation of amount, duration, or both is important. It's not just there to give some sort of advisory. It's a requirement that that has to be included in a non-modification provision in order for that non-modification provision to be effective. The situation we're left with in this case is that the court is without power to provide any relief for a maintenance judgment that has been impossible to perform, and where the obligor will never have any realistic possibility of being able to comply with that judgment. This is unique in the world of civil judgments. Child support can always be modified. This is very unusual, and I don't think it's too much to ask that before that heavy hammer comes down on someone, that the requirements of the statute be met. Thank you.
Thank you, Mr. Stas. Case number 126835, in re the Marriage of Betsy Dynako and Stephen Dynako, will be taken under advisement as agenda number 20. Thank you, Mr. Stas, and thank you, Mr. Dunn, for your oral arguments this morning.